I'm going to ask.
Check, check. 1, 2. Okay, make sure my phone's on.
So I think we have 5 minutes.
Get those ringtones going in here.
Well, you know, we'll just get a. I got you.
That's not right. You want me to put it in my pocket or you?
Yeah. The people didn't know exactly.
On this, I won't lose it, but I will.
So. Roughly, are you gonna make the decision of this? I don't think I've seen this all in the life.
You think I have more power than I do, you do. Brian, how's this? Are we on?
Hello?
Okay.
Hello?
Well, hello and welcome, everyone. Thanks for coming tonight. I'm Russell Korobkin. Most of you know that, most of you know who I am, but for those of you who might have been focusing on other things during the summer, Dean Mnookin was appointed to be the Chancellor of the University of Wisconsin at Madison shortly after the school year ended in the spring, and the Provost asked me to step in as Dean this year. While we conduct a national search for our next permanent dean. And I'm tremendously honored to do that and happy to be here. When the Supreme Court issued its opinion in Dobbs versus Jackson Women's Health Organization in June, I sent an email out to the community in which I said we would have an opportunity during the first week of school to engage with that important development, as well as some other important cases that made this a truly momentous Supreme Court term. So we decided then to move Whither the Court, which is one of the law school's really signature events, a bit earlier in the semester than it usually is. And so tonight I'm pleased to welcome a lot of you here in person and even more virtually to this year's edition of Whither the Court as also kind of a fall semester kickoff event for the law school. Whither the Court is the Allan C. Lebow Annual Supreme Court Review. Allan Lebeau was a graduate of the UCLA School of Law, class of 1972, a valuable member of our community, and a practitioner of corporate and bankruptcy law before, tragically, he was killed in an airplane crash just after his 30th birthday. Some years ago, his wife, Cindy Lebeau, also a UCLA law alum, who teaches constitutional law in the Department of Political Science and has also taught some courses here at the law school, along with Allan's parents and siblings, generously endowed a memorial fund to support this event, an event that Allan would have loved. And that endowment will support Whither the Court in perpetuity. So I want to thank Allan's entire family. Cindy is not able to be with us in person today, as she usually is, but she assured me that she will be watching on the live stream. So thank you, Cindy. Immediately after the panel discussion ends, for those of you who are here in person, we'll be having a reception outside in the Shapiro courtyard. Please join us then and take advantage of the opportunity to talk more with our 5 panelists, because I can warn you there won't be nearly enough time in our session to deal with all of the important issues we have to discuss. Finally, last thing before I begin, I want to acknowledge the presence of UCLA is on the traditional, ancestral, and unceded territory of the Gabrielino Tongva peoples. Each year, the Supreme Court issues consequential decisions, of course. But this term, as I said before, is really one of the most momentous in many years. It's clearly artificial and arbitrary to single out just 4 opinions for discussion tonight. Many others are very important as well. But with only 90 minutes, we had to make some difficult judgment calls. So tonight we're going to be discussing Dobbs versus Jackson Women's Health Organization, New York Rifle and Pistol Association versus Bruin, West Virginia versus EPA, and Biden versus Texas. And for this conversation, I'm really thrilled to have 5 outstanding experts from the UCLA School of Law faculty. As sort of from left to right here, Carrie Franklin is the McDonald Wright Professor of Law and the faculty director of both the Williams Institute and the newly formed Center on Reproductive Health Law and Policy, which makes her arguably the most overcommitted member of our generally quite overcommitted faculty. Professor Franklin is a leading expert on anti-discrimination law and reproductive justice, and today she's here to discuss primarily the Dobbs opinion. Eugene Volokh is the Gary T. Schwartz Distinguished Professor of Law and one of the country's leading experts on both the First and Second Amendments. Professor Volokh will be our expert tonight on Bruin. Blake Emerson is Professor of Law and an influential and important scholar of administrative law. Professor Emerson is going to discuss West Virginia versus Environmental Protection Agency. Ahilan Arulanantham is a professor from practice and the faculty co-director of the UCLA Center for Immigration Law and Policy. Before joining us on the faculty, he was senior counsel at the ACLU of Southern California. And this past term, he argued before the Supreme Court in the case of FBI versus Fazaga. But tonight, he's going to be our expert on Biden versus Texas. And Cheryl Harris is the Rosalinde and Arthur Gilbert Professor of Civil Rights and Civil Liberties, as well as our Vice Dean of Community, Equality, and Justice. Professor Harris is a leading scholar on constitutional law and race in the law, and we've asked her tonight to provide some general analysis of the court's term and trends. So please join me in extending a warm welcome to our distinguished panel. Professor Franklin, everyone in this room knows that the Supreme Court overruled Roe versus Wade. But could you start by laying out for us precisely what was the holding of Roe? How was that changed and partially modified 20 years later in Casey versus Planned Parenthood? And now what is the current state of the law after Dobbs?
Sure. And thank you so much for all of that. And to all of you for being here. I'm very honored and pleased to be on this panel, although not necessarily to say what I'm about to say for the next 10 minutes. So in 1973, in the Roe case, the court held that the Constitution protected an unenumerated liberty right to abortion. Abortion is not listed in the Constitution as a right, but the court interpreted the 14th Amendment to protect abortion and said state regulation of abortion will now be subject to strict scrutiny as it is a fundamental right, which means that the state's going to have a compelling interest in order to restrict access. The court also devised a scheme for implementing this right, where it said at the start of the second trimester, the state's interest in women's health becomes compelling enough that it may regulate to protect health. At the start of the third trimester, the state's interest in protecting potential life becomes compelling enough that it may ban abortion. That was Roe. I think it's always interesting to note that that was not a controversial decision. It was a 7-2 decision. When Justice Stevens was confirmed a couple years later, they didn't even ask about Roe. It was not what it is today at the time. That obviously changed starting in the late 1970s and throughout the 80s. It got entangled with party politics. Republicans who had historically been pro-choice flipped and became more anti-abortion, and that yielded Casey, which in 1992 curtailed the protections of Roe. And what it said was that Roe had underestimated the state's interest in protecting fetal life, which goes all the way back to the beginning of pregnancy. And so the new rule, we're upholding the idea that abortion is a fundamental right and the state's going to still have to justify what it's doing. But the new rule will be after viability, which we're going to say is about 24 weeks, the state can just ban abortion. Pre-viability, the state can restrict and regulate, but not in a way that unduly burdens the right. In other words, that puts a substantial obstacle in the path of a pregnant woman seeking an abortion of a non-viable fetus. So that was the Casey test. It was a less protective test, but it still upheld that general principle that abortion is a fundamental right under the Constitution. Fast forward another generation to Dobbs. This summer, the court overturned that general principle in Roe and Casey that abortion is a fundamental right under the United States Constitution, that it's subject to any form, that abortion regulation should be subject to any form of heightened scrutiny. Now, rational basis, the lowest form of constitutional review applies. Abortion restrictions are presumptively constitutional, and that's where we are now.
So the textual basis, right, for Roe versus Wade was the Liberty Clause of the 14th Amendment to the Constitution. The Supreme Court in Dobbs says, rather than finding abortion as a fundamental right under the Liberty Clause, because the Liberty Clause is relatively ambiguous, in order to identify a right as protected there, it has to be rooted in the history and tradition of the country, right? So the word liberty is clearly a broad term subject to lots of different possible interpretations, but you've been, of course, very critical of this methodology of constitutional interpretation of the Liberty Clause. Tell us a little bit about why you don't think it's a sound approach to giving meaning to a term like liberty to look to the history and tradition as it was understood by either the founders or, in this case, the framers of the 14th.
Yeah, so I mean, one of the big questions in constitutional law is, how do you interpret these broadly worded provisions of the Constitution that are underspecified? Liberty and equal protection in the 14th Amendment, I work on those two. They're very underspecified. They don't list what rights are protected. So we have to interpret what those mean, and it is not easy to do that. And the approach that the court in Dobbs took was to say, well, the only justifiable way to say that something is a liberty right under the Constitution is to ask whether it is deeply rooted in American history and our legal tradition. Has this right been protected throughout history? Although it's a little unclear what the scope and parameters of that history are, but has this right been one that we've always protected? And then the court said, no, look to the late 19th century. There was a criminalization campaign. There were laws passed barring abortion. Those lasted for much of the 20th century up until Roe was decided. That's not a history of protecting an abortion right throughout American legal tradition. Doesn't count. That was the court's assertion. So there is no way I can adequately voice or retail all of the critique of that approach, but I'll just talk about several different kinds of critiques that have been made about that history and tradition approach. One that I have written about, others have written about as well, is that it purports to be neutral and objective. It's a vision of judges as umpires. You can just look and objectively determine which rights are protected in history. It cuts the judge out. It cuts constitutional values and visions and policy making out, and it constrains the judge. And that, I think, is untrue. I think there are what I've called shadow decision points. There are 100 shadow decision points along the way that the court doesn't tell you that it's making a decision, but it actually makes a decision when implementing this history and tradition test. How do you define the right? What scope of generality, what level of generality do you define the right at? What period of history are we looking at? Are we looking at the founding? This court went back to the 17th century and looked in England and talked about commentators over there. What period in history are we focused on? Does it have to be an affirmative tradition of protecting the right, or can it just be a lack of laws criminalizing it? There are many, many, many judgments that need to go into determining what rights are deeply rooted in history and tradition, not to mention the fact that history is not just a series of facts that are uncontested and easily discernible. There's debate, especially about these big political questions in history about what the history shows. So one critique is that this is purporting to be neutral and objective, and that's problematic because there's a lack of democratic accountability, there's a lack of consistency and rule of law values, and we should be worried when courts do this. Another body of critique is if you freeze the meaning of our constitutional provisions back in the 18th century or back in the aftermath of the Civil War, you've frozen them at a time that the only people who were contributing to the conversation about what they meant were a small group of generally propertied white men. And you've frozen in time the meaning of broadly worded constitutional provisions like equality in a way that cuts out most of the people in this room, most of the people in America today, and that there's a democratic problem with saying that those constitutional provisions are frozen forever in hundreds of years ago, when we know that there were democratic deficits and we know that there were a lot of forms of exclusion and subordination. I would say another critique that folks have leveled at this kind of, well, one sort of related critique is that the court doesn't apply it consistently. Sometimes it applies a history and tradition test. Sometimes it applies an originalist test. Sometimes it doesn't apply either of those kinds of tests. And I guess I'll just end by saying the final category of critique that people have made is that it's a kind of meta critique that the framers and founders themselves didn't want us to interpret the Constitution in this narrow and limited or originalist way. They wrote the provisions in a broadly worded fashion because they understood that a word like liberty wasn't frozen in time. They wanted the Constitution to last throughout the generations. They understood that different generations would interpret liberty and equality differently, and they had just been through a civil war. They knew that the meaning of these provisions changes, and it's odd to go back and look at the substantive understanding and say we're going to be faithful to them, but not be faithful on the level of the interpretive technique that they thought we might be using. So there are a whole host of critiques about the approach the court has taken.
Great. The current status, right, as the court tells us in Dobbs, is that the question of the legality of abortion, right, is returned to the legislatures. Right, legislatures can decide to prohibit or to legalize abortion. Before Roe, abortion was a matter of state law. Right, there were states that prohibited abortion. There were states like California that permitted abortion. Now we've seen, after the Dobbs decision, just in the last couple of months, we've seen states move to criminalize abortion. We've seen some states move to sort of reiterate their support for reproductive choice. Might this be a matter for federal legislation, though? Is it necessarily a matter that is committed back to state legislatures? I think if you reading the opinions, the majority and the concurrences, it in some places sort of seems like that, but then in some cases the language seems to leave open the possibility of federal legislation. Does Congress have the power to, under the Commerce Clause or under some other provision, to either protect abortion across the entire country, prohibit abortion across the entire country, or both? Or are there some potential limits here that really makes this a state question for sure in the future?
Yeah, I mean, I think it's going to be a state question until Congress can get its act together, which will be maybe never, but maybe that Congress will get its act together and will ban nationwide or protect nationwide, and then this will be, I would predict, a case at the Supreme Court. So here's something for those of you who are in your first couple days of law school, something I did not know before I came to law school, which is that the national government is a government of delegated powers. When Congress passes a law, it has to point to a specific place in the Constitution that gives it the authority to do that. So the dean's question is, can Congress point to a place in the Constitution that would give it the authority to either ban or protect abortion nationwide? Interestingly, this is also an area, as you will see, every panel, but one of the themes of tonight will be, we are undergoing major change. This is a period of very rapid change at the Supreme Court. So one of the other areas that is undergoing rapid change is Commerce Clause doctrine. So I'm going to give you what I think the best reading under current law is, with the caveat that I don't know if that's going to be the law tomorrow. But my best reading under current law is that yes, Congress does have the power under the Commerce Clause to ban abortion, and it has the power to protect abortion. So the Commerce Power gives Congress the power to regulate interstate commerce. It can regulate the channels of interstate commerce, the instrumentalities of interstate commerce, or things that substantially affect interstate commerce. For a long time, for generations, the Supreme Court left it up to Congress to regulate under the Commerce Power. But in the 1990s, started to restrict Congress's power a little bit and say, on that last one, activities that substantially affect interstate commerce, the activity should probably be economic in nature. So it struck down the Gun-Free School Zones Act, and it said just having a gun in a school is not economic activity. So Congress can't reach and regulate it under the Commerce Power. It also struck down portions of the Violence Against Women Act. It says if somebody beats somebody up, that's not economic activity. Congress can't reach that under its Commerce Power, even though Congress had argued in both those cases that activity substantially affects interstate commerce, guns in schools, and domestic violence. The court restricted Congress's power. Here, however, with abortion, we have a medical service that is bought and sold. We have pills either that are bought and sold, or a healthcare provider providing a service that is paid for. This strikes me as economic activity. I think it's hard to argue that it's not, particularly since Congress has probably learned and would write the law either way, whether it's banning or protecting abortions that are performed through medication that has moved in interstate commerce or using implements that have moved in interstate commerce is banned or is allowed. Under current law, I think that Congress, that should be upheld under my current understanding of Commerce Power. However, new restrictions do pop up, so I can't predict in the future. I'll just, my final note would be, there are other provisions that Congress might cite. The spending power gives Congress the ability to spend in ways that could tilt one way or the other. The one of the most controversial ones I'll end on is the 14th Amendment. So Congress also has the power, the 14th Amendment gave Congress the power to enforce the guarantees of the 14th Amendment, to enforce liberty and to enforce equal protection. Could Congress argue that it was banning abortion in order to enforce the equal protection or the liberty interest of a fetus? Could Congress protect abortion, arguing that it was acting to protect the equal protection rights of women? Those will all be questions, but my best guess is that Congress, if it could get its act together, would have the power to do this either way.
Great. Another question about implications of the decision. What does the Dobbs decision mean for other rights that have been recognized by the court as being protected under the Liberty Clause of the 14th Amendment, ranging from the right to use contraception to the right to same-sex intimacy, same-sex marriage? Are these rights subject, do you think, to the same reasoning as the Dobbs court, or does the fact that in abortion is different in one way that might be important, which is that there's the fetus involved, right, in a way that you don't have when you're talking about, for example, same-sex marriage?
I am exercised about this, and I think you should be too. Here's why, and I'm saying this independent of your views on any of these substantive issues. So the abortion is not the only unenumerated right protected under the Liberty Clause. There's a whole line of cases, including the right to use contraception, the right of two people of the same sex to have sex, the right of two people of the same sex to marry, and a number of other rights that are protected. So the reason the dean is asking about those other rights is the logic of the Dobbs opinion would seem to have an impact or implications for those other rights, because what Dobbs said was, the only liberty rights that are protected under the Constitution are those that are deeply rooted in history and tradition when you define the right at a high level of specificity. Okay, I believe that all of those other rights, all of those other cases should come out the other way under this history and tradition test. Was there, deeply rooted in American history and tradition, a right of two people of the same sex to marry? No, it's almost absurd to argue that there was. There was not. You don't have to take my word for it. All of the dissenters in Obergefell, the marriage case, and in Lawrence, the same-sex sex case, argued that the court should use the history and tradition test, and that there was no right to same-sex sex, and that there was no right to same-sex marriage under this test. I agree with them. I think that is correct. If you are implementing this test, those rights also don't exist under the 14th Amendment. So now we have a situation, however, where feminists, people of color, LGBT people, progressives in general are expressing concern about the vulnerability of these other rights in the wake of Dobbs, given the logic and the test that the court has adopted. And the response has generally been, don't be ridiculous, that's hysterical, that's absurd, that's fear-mongering. So this is where I think the concern starts to come in, should come in for everybody. I'll say two things. One, it is quite something to see claims. So I'll say one of the kind of claims is no one is coming after those other rights. You shouldn't be worried about those other rights because no one's coming after them. They are safe, they are protected. We have all agreed at this point on basic LGBT rights and the right to contraception. It is, I read claim after claim like that, and open on the other side of my screen is laws being proposed in states like Louisiana that would ban contraception. We're facing a wave of anti-LGBT legislation throughout the United States. We have many elected officials and prominent candidates saying we should end same-sex marriage and expressing these views at the same time that there is a discourse about how it's hysterical to be concerned because we all have a consensus and those rights won't be targeted. You know, that's not as concerning to me. That's politics. People can shade things different ways. People can make all kinds of claims. People can say what they want in politics. I don't agree that those rights are so safe. Empirically, I do not agree that there's no vulnerability there. I don't think you can feel 100% certain that the right to same-sex marriage, particularly when we're not talking about overturning those rights, but chipping away at them. I do think there is a campaign to do that. But let's leave aside. What I want to focus on is the legal claim. The legal claim, which often takes the form of, don't worry, Dobbs is different. So what's that really saying? What's that really saying is, we can apply the history and tradition test in Dobbs, and we can apply the history and tradition test in all these other cases. And we can all agree that in all of these areas, the history and tradition test doesn't show a protected right. But don't worry, we'll find a way to make the LGBT cases come out the right way. We'll find a way to make the contraception cases come out the right way. Maybe we'll use stare decisis and say in those contexts, there's more stare decisis protection. Maybe we'll make a value judgment about the fetus that will differentiate Dobbs from the other claims. What I'm getting at is the idea that we have, on the one hand, a neutral and objective and consistent test here, but that actually, on the other hand, we're not going to apply it neutrally and consistently. We're going to find a way in those other cases to make it come out the other way, even though there's no history and tradition shown in those cases either. That, regardless of what you think of the substantive issues being discussed here, that should concern you, because that is a court that has abrogated an enormous amount of power to itself. That is a court that I think is not being honest and accountable and clear with the American people about how it's making its decisions. And that is a court that has, to me, veered out of control in a problematic way. So even if all of those other decisions were to be upheld, I still wouldn't be happy. So I guess I just want to end with this, and this is really not meant to be a leading question. Every time I ask a question, I think students think I have an answer, and I'm trying to. I'm a law professor because I'm full of questions, not full of answers. I know somebody who worked in a repro space for about 10 years litigating repro rights cases, and she just left to become the executive director of Take Back the Courts, which is an organization committed to court reform, like jurisdiction stripping, like expanding the number of justices on the court, like term limits, because her view was that really the only way these days to fight for reproductive rights is to work for court reform. And I just put that to you. Is she right? Is that right? Is that how you should think about any of these issues going forward?
Thank you. As much as I really, when you said stare decisis, I got really excited. I really wanted to get into that, but we're going to have to move on to Professor Volokh. Professor Volokh, let's talk about New York State Rifle and Pistol Association versus Bruin. In 2008, in the District of Columbia versus Heller, the Supreme Court, very momentous ruling, ruled that the Second Amendment provides an individual right to possess firearms for self-defense. Okay. That case specifically involved guns in the home, right? And the Bruin case involves the right to carry guns outside of the home. Okay, so obviously it's a different question in this case, but does Bruin, where the court expanded the right to bear arms to carrying arms outside of the home, is this really a significant expansion of rights, a significant change in the law, or do you see it as a more modest incremental change?
Maybe it's both. So if you look at the landscape, let's say 3 months ago, and depending on how you count it, 41 to 44 out of 50 states, any law-abiding adult could either get a license to carry a concealed gun or could carry the concealed gun without a license. And now that number is 50. Now, as it happens, at least 2 of the outliers were very big states, California and New York. And then there were a few others. But basically what this means is California is now like Oregon, like Washington, like Pennsylvania, like probably like Connecticut. Connecticut is one of the ones that it's not completely clear which way it went, but looked like it was de facto so-called shall issue, that the sheriffs had an obligation to issue licenses. Now, incidentally, interestingly, a state doesn't have to allow people to carry concealed. It could choose to require them to carry openly, in part because historically in the 1800s, that was a very common form of gun control. You can carry a gun openly because that's how honest folk do it, as opposed to those sneaky concealers. But as a practical matter, given current mores, I think most states will prefer people carry concealed. And in some states, I believe Florida is one of them, actually forbids open carry, but allows quite broadly concealed carry. So the change is very significant for Californians, but not all. Sacramento, for several years, has been shall issue. Anybody could get a license, basically, if they aren't disqualified. San Bernardino and Riverside, which of course are very heavily populated counties. But Los Angeles still makes a big difference. I'll probably be able to get a concealed carry permit, where before almost certainly that I couldn't.
And I'm sorry, you used the term, and just interrupt you for a second, you said shall issue versus in California, we call it a may issue?
Yeah, so the state level is may issue. It's up to the sheriff. And some sheriffs can say, no, we're not going to give it to you unless you're like facing a proven death threat. And some say, yes, like in Sacramento, if you're not disqualified or otherwise super suspicious to us, well, then in that case, you get a permit. And then there are others like LA County and some other counties where it looks like, you know, does the sheriff maybe like you? Maybe do you have connections? Maybe do you have like a job that the sheriff thinks is particularly dangerous, whereas maybe living in a dangerous part of town isn't enough. So the rule will now be shall issue. Now, here's why it's quite significant difference, though. Go back to 1985. It was flipped. 10 states were shall issue, except one of those 10, usually classified as shall issue, actually didn't require a license. That state was Vermont. That was the most liberal in not in the political sense, but the freest state for concealed carry in the country was Vermont. And 40 states were either may issue or no issue, where you couldn't at all, although many of those 40, you didn't even need a license for open carry, although by the 1980s, open carry in many places was sort of socially frowned upon. So what Bruin is most important in, first, it is important in that it changes the law in New York and California and a few other states. But the other thing, besides the broader jurisprudential point, which we're going to get to shortly, the other thing that it's important in is it preserves that as a constitutional right, that if people want to roll back things to the way they were in the mid-1980s, they wouldn't be able to, at least so long as Bruin remains the law.
All right, let's talk about, get into the detail of what this ruling says about constitutional interpretation, right? What the court's telling us. So the majority in this case scolds, takes to task lower courts for using an intermediate scrutiny approach to assessing regulations that infringe upon the ability to bear arms. So most of the courts of appeals had said after Heller that in a case like this, they would look to whether the regulation was substantially related to an important government interest. So there's a tiers of scrutiny approach that is familiar to all of you who have taken constitutional law already. And there's some balancing required, right, between the extent to which the right is infringed upon and the importance of the reason for doing it. So in Bruin, the court wipes this out and says, no, that's not the appropriate way to analyze the regulation. And we go back to here, we have some parallels with Dobbs, right? The court says, look to history and tradition at the time of the Second Amendment or at the time of its incorporation by the 14th Amendment to the states, and ask, was this kind of regulation sort of known and accepted in the history and tradition at that time? And if it was, then it's okay to have the limitation. If not, it's not okay, regardless of whatever harm the state can show that people carrying firearms, concealed firearms might cause. So is this you're a constitutional law scholar who has written about tiers of scrutiny and that kind of thinking and that kind of balancing for a long time. What do you make of this approach to constitutional law in interpreting the Second Amendment?
So I don't know. I don't know, because if you look at the way constitutional rights are treated, there are some areas where this kind of intermediate scrutiny or strict scrutiny or such is very well established. And there are other areas where it's almost unheard of. And there's always the question, like, how do you reconcile? So let's take an example, the jury trial clause. Now, the jury trial clause, if as to criminal juries, is not absolute. There have been the court has said for historical reasons, for example, if the crime is punishable by 6 months or fewer in jail, then because historically those have been seen as petty offenses, you don't get a jury. And likewise, you don't get jury trials in military cases and such. But imagine somebody said, well, you know, it's really important for us to prosecute murderers, or really important for us to prosecute hate crimes, or really important for us to prosecute people who attack police officers. And there's a compelling interest in doing that. And we're just afraid that because of public sentiment, it's just too hard to get convictions here. So murderers will walk free, or hate criminals walk free, or police abusers of police will walk free. So we think that the right to jury trial should be trumped by this compelling interest. I think our answer is no. No, there's a right to jury trial, and that is that. And if you can't get convictions before criminal juries, well, that's one side effect, maybe bad, but that is an understood by the framers, and to the extent you care about the framers, and the court does, understood by our legal system effect of that. Another similar example is the privilege against self-incrimination. Imagine there, like somebody says, well, what about for murder? Like we really, really need to catch murderers. So look, we're not saying we should torture them, but at least we should be able to call them to the stand and ask them, well, where were you this night? And if they say no, throw them in jail for contempt, or allow a jury maybe to draw adverse inferences from that. You can't do that. On the other hand, when it comes to free exercise of religion, even those, who I disagree with, but those on the court, historically was the left of the court, now it's the right of the court, who think that there ought to be exemptions from generally applicable laws for religious observers. They obviously say it's not always, it's not just based on history and tradition. There's got to be some way of overcoming this. It's just a presumption. It has to be rebuttable, and they're arguing for strict scrutiny. In free speech, it's interesting. the court has allowed a very, very few content-based speech restrictions under strict scrutiny. Although maybe the court would be prepared to get rid of that because it's actually not a critical portion of free speech law. Although then if you add, what about content neutral restrictions, like restrictions on the noise of sound amplification or restrictions on the time and place of demonstrations? Kind of everybody agrees that it can't be absolute right either. So there is this weird patchwork in different areas. And I don't think anybody has really explained when heightened scrutiny should be used, whether it's strict scrutiny or intermediate scrutiny, or whether it should be per se protection.
So what's your evaluation of the Second Amendment context then? Is the court, you agree with the court saying that this is a per se right, not subject to balancing, or do you think that's not the right?
Yeah, I'm inclined to say this is so, in part because, as with jury trial rights, as with a lot of other such very specific rights, there is a well understood government interest on the other side. And in fact, it's not just important, it's compelling. Preventing crime, preventing whether it's gun crime or any other crime, is a compelling government interest, no doubt. And then the question is whether a law is substantially related or narrowly tailored. It's often just a matter of a judgment call about how you interpret highly contested empirical data. And one of the things that I think really moved the justices is they saw lower courts basically upholding a vast range of regulations, including very burdensome ones, including ones like restrictions on 18 to 20-year-olds possessing guns, and a wide range of other kinds of restrictions, upholding them under intermediate scrutiny or even under strict scrutiny. And the justice's view was, if we allow them to do that, then basically they'll be able to write the right out of the Constitution.
So if you read Justice Thomas's majority opinion, I think, at least when I read it, the tone of it seems to me to suggest, boy, there aren't going to be a lot of regulations of firearms that are going to be upheld by this court. But Roberts and Kavanaugh concur, right? And maybe in part because of that tone, right? And so no, wait a second. We're not saying here that all regulations of firearms are per se unconstitutional. Give us a sense, if you would, about what you think the future is of firearms regulation. What types of statutes, state
Sure.
and maybe federal, right, are going to be permitted? Which ones are not?
Sure. So let me start with a few categories of ones that are very likely to be permitted. One is ones that the court has, rightly or wrongly, endorsed. So, for example, it has said bans on gun possession by felons are presumptively constitutional. It's an interesting question, how that should fit within history and tradition. On one hand, the actual prohibitions on possession by felons are relatively new. They're about 100 years old. On the other hand, back around the time of the framing, a lot more felonies, not all by any means, but a lot of them were capital offenses. And as a result, you would be barred from possessing guns or doing anything else. And more broadly, there is more historical authority for the proposition that if you are not seen as a responsible citizen, then you are going to lose gun rights. So maybe, but the important things the court has repeatedly said in Heller and I think McDonald, and was also echoed by that concurrence, that bans on possessions by felons or the mentally ill are constitutionally permissible. Interesting question, by the way. What does the mentally ill mean? Is it just people who are currently mentally ill? Or is it, as with federal law currently provides, that anybody who's ever been mentally committed, I oversimplify here, but basically loses gun rights forever? That's an interesting question. Another area that the court has said is permissible is restrictions, because of a history and tradition, restrictions on basically guns or other weapons that are seen as uncommon and dangerous, uncommonly dangerous. Machine guns, fully automatic weapons, generally very uncommon. The court has said restrictions on them are permissible. Surface-to-air missiles, I'm pretty confident they're going to say that. Another such category is bans on gun possession in sensitive places. Justice Thomas points to that, which could be things like schools or various government buildings and the like. Another area where I think there's some room for regulation, although less clear, are things that are seen as relatively low burden low burdens on the right. So, for example, there's a footnote in Justice Thomas's opinion saying you have a right to concealed carry, generally speaking, but requirements of licensing, if they are enforced kind of in an objective way, rather than just, well, it all depends whether we like you or not. And if they're not too expensive and not too time consuming, that's fine. Why? Because it's such a modest burden on your right. You just have to wait a little bit. So maybe some waiting periods might be upheld. Another thing is like restrictions on guns that don't have serial numbers. That doesn't really interfere with your ability to possess guns for self-defense. On the other hand, there are some other things like, for example, bans on possession by 18 to 20-year-olds, much dicier now. And there is some history of restrictions on at least gun purchase by 18 to 20-year-olds. So from a time when the age of majority was 21, which is throughout most of American history. So maybe that. And then other kinds of bans, I think, are just going to be pretty clearly struck down.
Great. Thank you. From gun control to climate change. Professor Emerson, West Virginia versus Environmental Protection Agency. This case has a very unusual and complicated procedural posture, but I want to ignore that and focus on the, okay, great, and focus on the merits of the case, right? So to sort of, to cut through the weeds a little bit here. It concerns a challenge to a proposed regulation called the Clean Power Plan, which was originally issued by the Obama administration, that would have required power generators to shift a portion of their production from coal to natural gas and cleaner sources of energy, wind, solar, et cetera. So I think it would help if you could start by explaining to us what's the statutory authority under the Clean Air Act that the EPA was relying on when originally promulgating this regulation, and tell us about also what the regulation that's substantively at issue here exactly would have done.
Great. So for those students of you who are thinking about taking administrative law, maybe now you'll find out if you're up for it or not. So the Clean Air Act and its amendments provides that the Environmental Protection Agency can regulate air pollutants. And back during the second Bush administration, the Supreme Court practically required EPA to conclude that greenhouse gases qualify as an air pollutant. And then it subsequently did so. And then what the Act next provides that that EPA can regulate existing sources of air pollutants like power plants. And the way it's supposed to do that is it's supposed to have each state or groups of states submit plans that reflect the best system of emission reduction for each of those air pollutants. And in the Clean Power Plan, the Obama administration determined that the best system of emission reduction would include a few components. And basically, you can put them into two boxes. One of the boxes was to regulate emissions at the source of the power plants, to reduce the emissions at, say, a coal-fired power plant. The other was to try to make grid level changes. So overall, looking at the electric grid as a whole, we're going to encourage states, require states to shift from coal to renewable forms of energy. And it was that latter part of the Clean Power Plan that the court ultimately found was unlawful in West Virginia v. EPA.
Okay, so best system, I'll just reiterate that language because this is the key language, right? Best system of emission reduction. That's what the EPA can essentially require. Yeah. And so it seems to me the question, tell me if I got this right, because this is complicated business here, that everyone agrees that the best system, if the EPA says the best system is to put scrubbers on the smokestack, like that's okay, EPA can do that, right? But here EPA says, well, the best system of emission reduction is actually to shift from coal to something else, right? And so does that count under the statute? Does that fall within the statutory authority? So the text doesn't say that EPA can require power plants to shift from coal to something else, but it also doesn't clearly say that it can't do that because it's supposed to create these rules that are the best system. Right. Okay. So seems to me like there's some degree of ambiguity here. Reasonable people might say it's a little bit unclear one way or another. So I took administrative law and I was taught and I clerked and I had administrative law cases and the law seemed pretty clear. When it's unclear like this, then the courts defer under the Chevron case, Chevron deference. Courts defer to reasonable interpretations by the agency. Right. So when I'm reading this, I'm thinking, okay, so the court's going to say that if the Obama administration interprets it this way, they can do that. If the Trump administration comes in and changes that, they say, no, we don't interpret that way, they can do that. But in this case, nobody talks about Chevron. I don't know that the majority even mentions Chevron versus NRDC at all. So why not? And what's going on here?
Yeah, so that's right. So the Chevron case, which is from the 1980s, stands for the proposition that if a statute is unclear or ambiguous about how much and what kind of authority an executive branch agency has, the courts are supposed to accept that agency's interpretation of the statute as long as it's reasonable. And it's important to note that this is not a doctrine that fell out of the air. Chevron is the placeholder we use to refer to a rule that goes arguably all the way back to Marbury versus Madison. But Chevron is the case that most clearly laid that principle out. But it's been many years, actually, since the Supreme Court has relied on Chevron to defer to an agency's interpretation of a statute. And that has to do with the shifting ideological composition and interpretive commitments of the Supreme Court over time. And the particular doctrine that seems to be replacing Chevron today is called the major questions doctrine. And there are two versions of this. You could think of it, there's a lighter version of the major questions, and there is a souped up, heavy duty version of it. And the lighter version, which kind of came into being in the 90s, it did kind of fall out of the air, was to say, if the statute raises an issue of vast economic and political significance, then the court is not going to defer to the agency's interpretation. It's going to settle the matter for itself. So an example of that was whether the Food and Drug Administration had the authority to regulate the sale and advertisement of cigarettes, especially to children. And the court said, well, even though the statute says that EPA can regulate drugs and devices that affect the human body, even though Chevron might apply, because this is such a big question, we are not going to defer to the agency, and we're going to read the statute for ourselves. And they ultimately concluded it didn't provide that authority. So that's the light major questions. The souped up major questions that really only dropped during the COVID-19 pandemic was to say, if it is a question of vast economic and political significance, whatever that means, we don't know what that means. Whatever that means, then the court concludes that the agency does not have the authority. So if it's a big question and the statute is not crystal clear, the agency doesn't have the authority. And so that is the conclusion the court came to with regard to regulating the overall grid in West Virginia v. EPA.
So do you see this as is this a substantive doctrine, or is it just in sort of a maybe not so revolutionary canon of interpretation that the court tells us that look, if we're talking about a regulation that's going to have a major implication for the economy, such as requiring all of these power plants to shift from coal to gas and to renewable energies, that and there's some ambiguity, we would expect Congress to have been clear if what they wanted to do was give the agency such broad authority.
Yeah, so there's something kind of intuitive about this idea, right? That, well, if something really matters a whole bunch, shouldn't Congress decide and not the executive branch agency. And I think certainly with regard to the light version of major questions, that makes a good deal of sense. But what you have to understand is these vague, ambiguous terms are the lifeblood of how our entire government works, right? So the statute books are positively littered with this sort of stuff. I mean, to give another example from the environmental protection context, the EPA is supposed to set national ambient air quality standards that are requisite to protect the public health within an adequate margin of safety. Well, is that going to pose a major question? And with regard to greenhouse gases, perhaps? Or you can think about the Federal Communications Commission regulating the airwaves as the public interest, convenience, or necessity requires, right? That sort of language is all over the statute books. And so if you take this principle to its logical conclusion, it seems to provide a hunting license for the Supreme Court to go after large swaths of the regulatory state of our modern form of government. And one thing I would also just emphasize is that if the court is saying that, and Chief Justice Roberts says this, that this is just an ordinary understanding of legislative intent, I think that's almost surely wrong. Because if you look at the legislative history of the Administrative Procedure Act of 1946, which is the quasi-constitutional charter of our regulatory state, there is specific evidence in the legislative history that members of Congress intended for agencies to resolve important questions as long as they did so through fair and inclusive procedures. And so when we're looking at all of these statutes, at least statutes that go back to the 70s and the 90s, when we're talking about this, there isn't clear evidence of legislative intent. The strongest case for the major questions doctrine is that it is a principle of statutory interpretation that reinforces what's called the non-delegation doctrine, which is a rule of constitutional law as opposed to administrative law. Administrative law is primarily about statutory law. The non-delegation doctrine is a rule that says that Congress cannot delegate its legislative power to the executive branch because Article 1 vested in Congress, so it can't wander anywhere else. And so one way to think about what the court is trying to do with major questions is to reinforce that principle through statutory interpretation by making it more costly, harder for Congress to make those kinds of delegations. But it's very controversial across the political spectrum whether it's appropriate to use statutory interpretation in that way.
Mm-hmm. So there are these very broad implications for sort of the future of the regulatory state.
Yes.
Here. But let's just end by talking for a minute about climate change in particular, because as much as you and I love the arcana of administrative law, the reason that this case has gotten so much attention is because of the concern that it will hamstring the government's ability to do what's necessary to fight climate change. So could you speak to that a little bit? Is this decision likely to have that effect on our ability to stop climate change?
So this decision, the actual holding of this decision does not totally debilitate our ability to address climate change under the existing legal framework, as well as laws we might enact in the future. Because the holding itself is really just about the specific issue of whether EPA can regulate existing sources of pollution in this comprehensive grid-like fashion. So they can't do that under the current legal regime. The thing is, it is likely that this ruling is going to have downstream consequences for many other sorts of ways in which EPA might regulate climate change, especially because the court has still been very unclear about what counts as a major question. We still don't know exactly the answer to that. Justice Gorsuch in his concurrence offered some tips that may or may not be valuable, but it's very amorphous. Interestingly, Congress just passed a massive piece of legislation, the so-called Inflation Reduction Act, which all includes a huge amount, historic levels of funding to encourage shifts to renewable energy through all kinds of subsidies and tax incentives. And the statute includes some language that explicitly says EPA has the authority to regulate greenhouse gases. But otherwise, it leaves West Virginia v. EPA in place. So that's kind of an indication of where Congress has a lot of leeway. For now, if Congress wants to spend a whole ton of cash in order to try to address climate change, it seems like it has a long leash right now. If it comes to regulatory measures requiring private parties to do X, Y, or Z expensive thing to address climate change, I think it's likely every time that happens, it's going to raise a major question objection. This is also coming up. This is also likely to come up with regard to the Securities and Exchange Commission, which is requiring climate-related disclosures to investors. You can bet that there will be a major questions challenge to that. You can see major questions challenge to efforts to regulate the sale of ghost guns, which are hard to track. Any number of important regulatory initiatives, you can slap this major questions lens on them, because the court has never been clear about what is and is not a major question. The COVID-19 pandemic, the court said that the Department of Labor, the Occupational Safety and Health Administration, could not impose a vaccine or testing mandate despite incredibly broad statutory authority, because the court thought the question qualified as a major question, and the statute says nothing about vaccines, right? So you can see that same principle being applied again and again across the whole terrain of issues that the regulatory state covers, which is to say almost everything.
Great, thank you. Professor Arulanantham, Biden versus Texas. So here we have another case where there's a regulatory battle between the Trump administration and the Biden administration in this case. This is the so-called Remain in Mexico case. Can you start out by describing the Remain in Mexico program, the migrant protection protocols that are at issue in this case? The Trump administration promulgated this program, and then the Biden administration moved to withdraw it, right? So tell us about exactly what's at issue in this case.
Sure. So since after World War II, really in the 1950s, the US has had a commitment that when people come here fleeing persecution, they can seek asylum. That's from a treaty, the Refugee Convention, and that is implemented by a federal law, the Refugee Act in 1980. And so, that's a sort of a very basic feature of American immigration law, that when people come here, they can make a claim and get at least an interview from an officer, and depending on what happens there, a hearing in front of a judge, where if they can show that they face persecution in their home country, then they can get protection here. And I think it's fair to say that the Trump administration really, really did not like that protection and sort of went to war on it and tried a number of different measures to try and stop it. They said you can't seek it if you are not entering in a port of entry, which had never been done before. They said you couldn't seek it if you'd gone through a third country. That got struck down. And then they said the Remain in Mexico policy, which is basically you can seek asylum if you've come here, but if you're entering via the southern border, you have to wait in Mexico for your day in court. And implemented against a backdrop where there are very long wait times for court and people have no place to live. The effect of this was in 2019, before it finally went into effect, was really to destroy access to the asylum system for a huge number of people, tens of thousands of people who were processed through the system. It had massive, massive effects. Now we look back pre-COVID, but it created, really for the first time in modern history, very large refugee camps on the border with Mexico. These were extremely dangerous places, became sites of violence and lots of healthcare problems. People had no access to lawyers through the system. It's already really hard to get a lawyer when you have a case going through immigration, but it was basically impossible. It was basically impossible to come to court. So, the loss rate was, well above 90%. The vast majority of those removal or deportation orders entered against people for failing even to come to court. And you can imagine this is like if you live in a refugee camp and the court is supposed to be sending you a notice telling you to come to court, people couldn't even live in the same place for more than a few days, right? So it effectively ended the asylum system for a huge chunk of people. And then, as you said, when the Biden administration came, President Biden actually, then candidate Biden, in a debate, criticized this and said, look, I don't think this is right. It's been a basic thing, part of our asylum system. You can come and seek asylum, and you get to seek it from within the country. He said that in the second debate. It was quite remarkable, actually. And then not too long after coming into power, the Biden administration wrote a memo that ended the MPP program.
So let's bear down on the language, because this is a statutory interpretation case, right? So let's sort of hone in again. So one portion of the statute in question says that permits the government, says the government may return a person seeking asylum to the country where they entered from. So as I understand it, there's no one saying the Trump administration lacked the authority to return people to Mexico, right? But it says may. They may do that. So the Biden administration came in and said, okay, we may do that. We're not going to. Okay. But I think, and you can correct me if I'm wrong, I think the problem that makes this, a little bit more complicated matter is that in another part, the statute also says that the government shall detain any undocumented person seeking asylum until they decide whether they're asylum, until they adjudicate the asylum claim. Right? But the problem is that there's not enough money allocated by Congress to house all of the asylum seekers while they're waiting the long period of time. Not enough money to house them. There are not enough judges to hear the cases, so they drag on forever. So the consequence is they're under the Biden approach, they're allowed to remain in the country, but not in detention, right? So as I understand it, the question is, if you do not, the argument I think is if you shall detain asylum seekers, and you may return them, right? If you don't detain them, must you then return them? Right? So talk a little bit about this sort of problem of comparing different portions, integrating different portions of the statute, and how did the court resolve this case?
Yeah, so the history and maybe a little context help a little bit. So there were challenges, legal challenges to the Remain in Mexico program during the Trump administration. Actually, one of them litigated in California by colleagues of mine, then colleagues of mine, I guess the ACLU of California, said that there was no statutory authority. So there actually was, I think, quite a compelling statutory argument. They won it in the Ninth Circuit, that there isn't statutory authority to send people seeking asylum back to Mexico. But that case went away. The Supreme Court had actually granted it, and the Supreme Court was going to consider that case. Then the Biden administration, they won the election, and they said, we're going to end this program, and that case went away. Then Texas sued, challenging the Biden administration's decision to end this program. And they made exactly the argument that you were saying, Dean Korobkin. They said, the statute says you shall detain. So yes, it's true. The statute also says that you may return people to Mexico, presumably meaning you don't have to, but the statute also says you shall detain people who are coming here without proper documentation and who are seeking asylum. And so Texas's argument was like, yes, it's true that it says may, but that's assuming, right, that the government will otherwise lock everybody up. Right? And this is a really important underlying premise here, right? The assumption underlying here is that the statute requires the government to jail people seeking asylum while their cases are pending. And that, I mean, if you just step back a little bit for context, I mean, that's a striking thing. Almost every country in the world, including, the European countries, which are signatory to the Refugee Convention as well, they don't jail people while they're waiting for their day in court in asylum cases. But the US, they're not the only country, Australia, there's some other countries, but the US does this. And we haven't always done it. We didn't do it at all between 1958 and 1980. We did it only for a very small number of people, even for years after that. But now the US jails, like right now because of COVID, it's all complicated. But even before COVID, the US jailed huge numbers of people who were coming here and saying that they were fleeing persecution and asking for asylum. It's a striking thing. And what Texas was arguing was, you have to do that because the statute says shall. And so, you only actually have two options under the statute. You can lock people up or you can return them to Mexico. And if you read the provisions together, they said, then that's what's required. And the court rejected that, obviously, and sort of said two things. One thing they said was, well, no, it says may. So may means may, doesn't mean shall. So you can't sort of put these together. The other thing they said, which I think was very important, was nobody had ever read the provision this way before, before this. The law creating this return to Mexico authority is from 1996. And after that, you've got, the Clinton administration, the W. Bush administration, Obama administration. None of them interpreted it this way. All of them let some number of people into the United States without locking up every person seeking asylum. So they said it can't be that this is actually that every single administration has been violating this law continuously since 1996. That would be odd. And then the other thing they said, which I thought I was glad they said it. This authority, there's another authority, which is an exception to this mandatory shall detain language, which gives the government the power to what they call parole. It's a funny use of the word parole, but it basically means you can let people in, including while they're seeking asylum. It's not limited to that, notwithstanding the shall detain language. The shall detain language actually is old. It goes back to 1903. And this parole language has existed in some form or another, going back a long ways too, both of them long before the return to Mexico provision. And so it said, look, there's always been this exception. The Supreme Court has validated that in this case, the case that I argued, actually. This is why I was losing my mind during this argument. It was like, but you said, because we had challenged the detention authority, the authority to jail people seeking asylum. And the government had said, hey, look, but we don't lock up everybody. We can parole some people. We lock up some people and other people can get let in. And then when the Supreme Court ruled against us on that, they said, look, they don't lock up everybody. They can let some people in. And so then, there was this Supreme Court case which said that. And so the government relied on that to say there's this other exception besides returning people to Mexico. You can let some people in. And they read that as a sort of an exception to the shall detain language, which authorized then the government to not be put in this choice, otherwise forced choice of either lock them up or return them to Mexico.
So as you suggested, this is a big, this is a hot political issue, right? You pointed out President Biden mentioned this, in the debate, so we're not going to do this, right? If we're elected. This is a big win for the Biden administration here. Should this be seen as evidence that the court's conservative majority, in all the other three cases we talked about, the court's conservative majority votes in lockstep, right? In this case, that doesn't happen. It's 5-4 decision in favor of the Biden administration, and presumably upholding a policy of the Biden administration that conservatives don't like. So should we see this as evidence that the court's not as ideologically driven as this year it's often been accused of being?
So I think this is complicated. Certainly there's a huge part of the anti-immigrant conservative movement that would have been thrilled with a court decision that did basically what Justice Alito's opinion for 3 justices. There's two dissents, right? Says, which is you have to lock up everybody or return them to Mexico, right? On the other hand, it's a very, very narrow victory. There's this argument we've been talking about whether the statute authorizes this. There's another challenge to the program, which is an APA arbitrary and capricious kind of challenge that the memos that justify this program are insufficient. And the court says that's still alive. You can still litigate that in the lower courts. I was on a call this morning, because I should have mentioned this at the beginning. SILP, the Center for Immigration Law and Policy, filed an amicus brief in Biden v. Texas, where counsel, my colleague Monica Langarica, is actually counsel in a case challenging the procedures used for this program. So we're very much interested in this. I was on a call this morning about the remanded case, and a lot of people are assuming that the ban, the order requiring the government to resume this program, keeping people in Mexico, is going to go back into effect because the district court in Texas is probably going to issue it again because the Supreme Court decision creates space for that. So in that sense, it's a very, very narrow win. And at the same time, there are other things I won't get in. We don't have enough time, but there's a jurisdictional holding in the case, which is coupled with this other case, also decided this term, Garland v. Gonzalez, which basically kills off class-wide injunctions. It's basically impossible for people to get class-wide injunctions to stop wrongful interpretations of the immigration laws. So they're sort of doing a lot of really terrible things to immigrants' rights, but at the same time, giving this narrow win. to me, it reminds me a lot of the DACA decision from last year. DACA decision was hailed as the, huge thing. They didn't kill off DACA, which is true, but it was a very narrow win. It preserved the ability for them for Texas and other states to come back and kill off DACA, which is now probably going to get teed up very soon in the Supreme Court again. And meanwhile, they're doing lots of other terrible things, stripping the court's jurisdiction over habeas petitions and by immigrants and all kinds of things like that. So yeah, I think that I'm sure that there is some truth to that, in the sense that it's not exactly what the most extreme kind of wanted, but at the same time, it is chipping away in significant ways at the protections available for immigrants in the federal court system, and this decision does that too. Great,
thank you, Professor Harris. But before I ask you for some sort of broad analysis of the term, I want to give you a chance, because I know there are a lot of consequential decisions this term, not just these four that we focused on. So before we talk about broader trends and conclusions, are there any other decisions that you might want to mention that people should, legally sophisticated people should be aware of and pay attention to?
There's probably a long list, but I'll just say that there is one involving the question of extending public benefits to religious institutions. This involved Maine's provision that prescribed the allocation of funding to private religious educational institutions. Maine has a situation where it doesn't have public secondary schools in all of its districts, and in rural areas, it gave the option to parents, pick and choose, will pay, except you can't pick a religious institution. The court basically struck that down and said that that was a violation of the free exercise clause. There is a strong set of cases preceding that sort of predicted that this is where they were going. The dissent points out that this is basically reading the free establishment or the establishment clause out of the First Amendment. For those of you that take First Amendment, basically, one provision says that the state shall not basically establish any religion. The other protects the free exercise. And so you have a debate between the majority and the dissent regarding sort of how to read these two things together. So that's a very interesting case. There's also a very interesting background to the question of the establishment of private educational institutions that I have an interest in as a sort of historian of civil rights, which is the establishment of a lot of private religious institutions, particularly in the South, were to avoid desegregation. So there's a kind of a really interesting intersection on that point. So, but there's more, but we're not going to do that because I think we got too much else to talk about.
We have a lot. So let me give you a chance to offer some maybe more broader conclusions about the future of constitutional law from these key decisions of last term. So what does this say to you about where we're headed and what to look for in the future?
Well, I was actually just talking to Cary as we were running in the door here, saying that one of the challenges is figuring out how to teach the course next semester. But apart from that sort of more narrow question, I think the big takeaway for me is that I would call this the lost cause court. Not lost cause in the sense that there's no point in thinking about litigating or bringing cases to the court, but lost cause to the extent that if its objective is to rebut the idea that it is engaged in partisan politics, I think it is lost. And it will not, I think, be able to refute that presumption. I liken this, and I want to go back, in some ways, I think past is prologue. So again, I said I'm interested in history. So part of what I read this through is the lens through what the court has done in the past. And so in 1954, when the court decided Brown versus Board of Education and overruled Plessy versus Ferguson, there was a famous Harvard law professor named Herbert Weschler who said, I really like this decision, but I don't really understand the logic and the principled basis for it. I really like the outcome. It's kind of like what Professor Franklin was saying. There's a question about the logic. So Weschler says, I like the outcome, but I don't understand the logic, because for me, this case isn't about discrimination or exclusion or segregation. It's about competing associational rights. It's about the right of white parents to disassociate versus the right of Black parents to associate. And those are both sort of equally positioned rights. And what is the principled reason that the court is giving for choosing the rights of Black parents to associate over the rights of white parents to disassociate? So for Weschler, he said, Brown doesn't answer this question for me. And in some respects, what Weschler was rehashing was something that William Rehnquist, who was then a clerk for Justice Jackson was one of the judges that sat on the court deciding Brown. Rehnquist later became Chief Justice of the Supreme Court. He wrote an infamous memo for Justice Jackson, arguing why Plessy should be upheld and it should not be overruled. And part of what he said is the court is being asked to read its own sociological views into the Constitution. And that actually undermines legitimacy. If the court is seen as doing nothing more than enacting its own preferences, then why do people that disagree with it accept the opinion, right? Needless to say, there were people that took issue with Professor Weschler's framing of the question. And another colleague of his, Professor Black, said, wait a minute, there is a neutral principle involved here. The principle is called racial equality. And so the question is simple. If equal protection guarantees Black people that they will not be disadvantaged by state laws, and segregation is a massive intentional disadvantaging of Black people by state laws, then it's a violation of equal protection. And even, he said, if this results, this is Black, when the directive of equality cannot be followed without displeasing the whites, then something that can be called the freedom of whites must be impaired. So for Black, he's saying, look, equal protection kind of tells us that this is the frame. He also says it's actually laughable to frame this as a question of association versus disassociation when the system of segregation, which was America's version of apartheid, was very clearly put in place to subjugate people. So I say all that to say that this was a segue to Derek Bell's famous essay on Brown, in which he said, and he gives his analysis of why the court in 1954 changed its mind. And basically he says it has to do with epic events outside of the court. It had to do with the ending of World War II, what happens after post-World War II, to a dispensation of segregation that now has put the United States in disadvantage when it's competing with the Soviet Union for influence in the developing world. The developing world has the emerging nations coming out of Africa and Asia, and they're looking at the United States and saying, this is the democracy that you want us to emulate? So Bell's analysis focuses on these external pressures that he says actually impacts how the court begins to see things. But he points out that even while Justice Black analysis of Brown is correct, that Professor Weschler's analysis is actually the way in which a lot of the dominant view of a lot of whites feel. That is to say, this is about competing associational rights, and I don't see the principle involved here. I guess I want to say that with respect to the rights of historically marginalized and subjugated groups, I think the majority of this court sort of reflects a kind of Weschlerian kind of framing of rights. It's a vision in which rights questions are kind of framed in terms that are abstracted from lived experience, abstracted from history, and abstracted from the present reality. And what that means is reproductive rights, for example, and decisions about women and people who can become pregnant are disconnected from the actual experience of subjugation. From, for example, Michelle Goodwin has a couple of really powerful essays, I commend them to you in the New York Times, on abortion, in which she says, look, the history of forced birth and reproduction of Black people, of Black women in particular, cannot really be divorced from this question. The history of the subjugation of disabled people with respect to their reproductive rights cannot be divorced from this situation. But the court manages to do that because it says it reduces it to a matter of competing preferences. In fact, in Dobbs itself, the majority says the courts, quote, cannot substitute their social and economic beliefs for the judgment of legislative bodies. Kavanaugh says the court doesn't take sides on the issue of abortion. So then it's sort of preferences, just sort of competing preferences. You apply rational basis, you're done and dusted, right? I think that this is not a successful, this is not going to be successful in avoiding the claim that this court is engaged in partisan politics, in part because the notion that that the court is not applying its own beliefs and value judgments is really belied by the reaction to it. not just the reaction by progressives and liberals and those who are opposed to the outcomes of these decisions, but by many of the supporters of gun rights and the supporters or opponents of abortion who see these outcomes as the consequences of their political power and the ability to put a president in office that would appoint judges to achieve this outcome. So to the extent that the court is trying to engage in rationales that say we're not engaged in partisan politics, we're standing above it, and this is the source of our legitimacy, that's why I call this the court of the lost cause.
So I was really, I'm still interested in the very first thing you said, and I think it relates to everything you said after that, which is, how do you teach constitutional law now? How are you going to change the way you teach your class as a result of this term specifically, and this in the new the 6-3 conservative majority of the court?
I'm going to talk to Cary. It's what's going to happen. Here's the thing. I don't think anyone is naive enough to think that politics don't influence the court. But one of the things that has been a real challenge in the context of teaching constitutional law is, one, it's an oddball in the sort of first year curriculum. Everything else is either common law or it's statutes. And then here I come with this thing that's got all these language in it that Carrie's talking about, and talking about all these cases where it looks like the court is shifting with the political winds to some extent. And so there's a deep sort of attraction to a kind of cynicism that says, well, this is really just all politics. Why are we even learning this? I mean, maybe we would do better to treat this as a political science course and stop treating this as a course in law. I don't have a good answer to that. But here's what I would say. There are, for one thing, and it goes back to something that Ahilan was talking about. There is a sort of, and I think Cary as well, there is an importance in sort of understanding the doctrinal structure in terms of whether or not one litigates, or whether or not one is arguing for a client, or whether or not one is working in the state legislature. It's just really important to understand the language in which these things are being fought out, right? It's like learning another language for having a political fight. So I would argue to some extent there is sort of a utilitarian value in learning it. Beyond that, I do think that there are some ways in which some of the debates involved in con law really go to the core of who we are. That doesn't mean that we are going to agree, but they are an important sort of set of contestations regarding what we see as being the relationship between the state and the individual, between the relationship between various aspects of the state. This is a place where we can talk about the values questions in ways that are important, even as we can maybe disagree about them, and even as we can maybe, as I do, rail against this court for its inconsistencies and for the problems that I see that it manifests itself. Whether that's going to work, I don't know. But I mean, I genuinely think that there is value in understanding that there is, one, a utilitarian value, and one, an important set of normative debates in here that we need to tease out and get at. So that's going to be my shtick anyway.
And a perfect way to end our formal session. Please join me in thanking our fabulous panelists. Thank you all for joining us. And those of you who are here in the room, please come outside and